News and information station.
Welcome back. With us now is Malcolm Futhey. We are talking about class action lawsuits. Malcolm, before the break, we were talking about, how do you protect your interest in the class and what to do if you get a claim for them. Now, if in that we had a discussion of whether or not you think the claim is fair and adequate. If I don't, what do I do there? Do I run and grab another attorney, or what do I do?
Yeah, that's a good point. I guess to clarify that, we should probably go through the whole process of what happens. Sometimes you'll have a class action that will go to trial and a judgment will be rendered. And in that instance, there's no objection. You simply submit your claim form. But what happens in most cases is that you have a settlement of the class action. And in a settlement, what happens is that the parties, the representative plaintiff and the defendant, will go to the judge and they'll request a preliminary approval of the class settlement. And then if the judge approves the settlement, then a notice goes out to the class, which is what happens whenever you receive the claim form. Now, whenever you receive the claim form, there will be a later fairness hearing. It's called the final fairness hearing in federal court. And at that final fairness hearing, if you submit your objection, you can submit objection to the class settlement, and you'll be given an opportunity to be heard if you choose. So if you find that you are involved with the class and you are a member, because you have to be a member to object. If you find that you're a member and you'd like to object to a class settlement, then you can simply file your objection with the court pro se on your own behalf. But it doesn't happen very frequently in Memphis. I don't know of any lawyers who file objections frequently, but in Chicago and in New York, and in the courts where I used to practice, there are lawyers who basically build a career out of objecting to class actions. And what they'll do is they'll find ways in which there will be problems for the class, whether by notice, whether by insufficient funds, whether by ineffective results. And they will file objection and they'll present an objection to the court. So there are attorneys you can contact who will present the objection for you. It's difficult to find in Memphis, but I believe if you do search them out, there should be somebody willing to help you out, especially if you have an unfair settlement. Mm-hmm. Yeah.
Now, I know earlier we were talking and you said there's sometimes been people that have objected that the claim is too much. Who would ever say that a claim is too much?
Yeah. When I was clerking for a judge, we would have some objections filed where it was basically just an objection to class actions generally. And they would say that the defendant and the plaintiff were both greedy and that nothing was fair about it and that there's just way too much spin on it and that it was an inefficient result. So, but in the end, typically what you do see is that you do see behaviors and business patterns change to accommodate. For instance, we keep going back to the Verizon example, but in that, the early termination fees have been changed so that you now get a credit for every month that you are a customer of Verizon. So you don't get hit with a $175 fee if you decide to cancel your service a month before your contract ends. Mm-hmm. And other companies have followed suit, AT&T and Sprint. So there is a benefit that is seen through it. So I think some of the criticism is unfounded.
Well, and then with all of this, I know we keep sort of sideswiping the issue as far as that these are mainly in federal court, but there are some that are also in state courts?
Yes, there are some in state courts. Typically, we refer to the federal courts because the federal courts created Rule 23 that, especially Rule 23b3, that established the pattern, the procedure for class actions, and a lot of states followed suit. And in a lot of states, you have just a lack of case law. So the states will defer to federal case law. So typically, you'll look to federal court to figure out the proper procedure or the proper path to take in a class action. But you do have some states, for instance, in Texas, Texas State Court, the Supreme Court decisions down there have pretty much rendered class actions null. There are so many procedural hurdles you have to overcome. Filing a trial plan, there are about 9 or 10 steps, And then if you do obtain a result, then there are many ways in which it can be a negative result for the class members, even if you win. So it's so in Texas state court, you really don't even see any class actions. Some states call it by a different name. You'll hear it mass tort or mass action, but most states have some form that is similar to, or if not directly patterned after, the federal rules and similar to the federal class action.
So I guess one question that I think a lot of people might have is if they have a claim, say they've got a steering problem on their vehicle or something, they go in and they have it repaired at the dealership and they find out that this is breaking a lot.
Yeah.
Do they then need to go in and talk to an attorney and say, hey, maybe we've got a possible class action? How does that proceed from there?
Yeah, well, typically it's not the individual or the client, it's not the individual who creates or proposes the class action. If you have any type of problem with your car or in anything in particular with any specific defendant or company, then you can consult an attorney and focus upon your own individual claim. But if you do go and see your attorney can advise you whether it's possible that there is a class action. And if the attorney doesn't have the experience or the resources to pursue the class, then that attorney should be able to refer you or have somebody else associated with them to build a class action, because there is the courts are very protective of the class. So not just any attorney can jump in and be class counsel for a class. There's Rule 23G, which outlines the requirements for class counsel. There's experience requirements, there's familiarity with the case, and the resources to pursue the class action to conclusion. So, but typically, if you see a pattern, if you see some type of repetitive pattern, then you can there's a possibility of a class action. But you should defer to your counsel on that.
Okay. Our time is up for this edition of Legalese. We would like to thank our guest for taking time out of his busy schedule and to be with us and sharing his thoughts and insights. If you'd like more information about Legalese or any other program on GHS TV, please refer to our website at www.ghstv.org. Thank you for joining us today, and be sure to join us next month for more discussion on legal topics. Until then, I'm Vince Perryman. Thank you for watching.